Welcome to Sumner School Business Immigration Basics. My name is Emily Sumner, and in this video, we are talking about the National Interest Waiver Green Card Classification, also called the NIW. The NIW classification falls into the EB2 Green Card Classification. In general, this particular classification does not require an employer to sponsor you, although an employer can sponsor you for this particular type of filing, but it's not required. Within the NIW classification, there are two particular paths that you can take. One is to show that you have what's called an advanced degree, which means a master's degree or equivalent, which is generally defined as a bachelor's degree followed by 5 years of progressive work experience, or to show that you meet the requirements for exceptional ability. To show that you meet the requirements for exceptional ability, you have to show that you meet at least 3 out of 7 criteria. We're not going to get into those criteria in detail in this particular video, but know that they are similar to, but not the same as, the criteria listed for the EB1A classification. And we have a previous video on the EB1A classification if you're interested in checking that out. Once you have shown that you meet either exceptional ability or advanced degree, you have to then show that you meet the requirements for the National Interest Waiver classification. There are 3 prongs, and they are based on case law, namely the matter of Nanisar. The first prong is that you have to show that your proposed endeavor, which means the project or the work that you'll be working on pursuant to the NIW, is both of substantial merit and of national importance. For any one of these prongs that we're talking about, you can make creative arguments. There are different arguments that you can make. But for example, for this first prong, you could show that your work is in the economic interest of the United States, or you could show that it has the significant potential to positively influence research both within the United States and outside, potentially, of the US. You only have to show national importance, but you can show a global impact. You could show that your proposed endeavor will significantly enhance a manufacturing process in the United States. In general, you have to show that your proposed endeavor or your project that you'll work on is significant and is of national importance within the United States. The second prong is you have to show that you are well positioned to advance your endeavor here in the United States or your proposed endeavor. That prong is all about you. So yes, you have to show your background, your qualifications, how it is that you are qualified to advance your proposed endeavor, but it's also important to show forward motion or to show your plan for making forward motion with your proposed endeavor. So that can be things like submitting documentation regarding a model of your proposed endeavor, a plan, a business plan, interest from other people within the industry or other people that the proposed endeavor would positively impact. It's important that you show that your work is of interest to people, industries outside of your particular employer if you are employed in the United States right now. And you don't have to be. You can be working overseas or overseas in general. But you do have to show that your work is of interest and will potentially has a significant potential to positively advance the work or the interests of people outside of your particular immediate network of contacts. The third prong that you have to show is that on balance, it is in the interest of the United States to waive the labor certification requirement and the job offer requirement that is typically required. So we're going to talk in subsequent videos in a lot more detail about the labor certification process, but know that in general, many of the employment-based green card options require the labor certification process. That process is in place to protect US jobs and to protect US wages. So you have to show, again, that on balance, looking at all these other factors, that it is to the benefit to the United States to waive that requirement for this particular situation. Again, you can make creative arguments. You could argue that it is impractical to go through the labor certification process. You could argue that you are creating jobs or will create jobs in the United States, so it doesn't make sense to go through the labor cert process. It could be that you have unique knowledge and skills that would not be found if you go through the labor cert process, which focuses on the minimum requirements for the position. So again, you can make creative arguments. But it is important that you meet each one of these three prongs. It's not an and or, it is each one of these three prongs. In general, the process for the NIW filing, again, you can self-sponsor or an employer can sponsor. You have to submit the I-140 petition, that's the form that you submit, along with substantial documentation to show how you meet these requirements. When your priority date is current, and your priority date is set by the date that you file the I-140 petition, if you're not sure what a priority date is, go back to our previous episode on the visa bulletin and the priority date explanation. We have a detailed explanation there. But once your priority date is current, you can file the I-485, which is the application for permanent residence. It's possible in some circumstances, potentially, depending on what the visa bulletin says, that you could file concurrently. Or when your priority date is current, you can proceed with consular processing and obtaining what's called the immigrant visa if you are outside of the United States. So that is the information we have on the national interest waiver classification. Again, falls into the EB2 category. Our next video will be a high-level comparison of the quote-unquote fast track options, which are the EB1 options and the NIW. Until next time, my name is Emily Sumner with Sumner Immigration Law, serving clients throughout the United States and from around the world with employment-based and family-based immigration cases. Take care.